Good morning. May it please the court, my name is Chelsea Moore. I'm here on behalf of the appellant, Charles Hardy Jr. I'd like to reserve 5 minutes for rebuttal. This case is about a man who wanted to tell his story, but was misunderstood, shut down, and ultimately denied. I can't overcome the fact that a proper Momen hearing was conducted in this case, and Mr. Hardy, on the record, waived his right to testify. However, I am here to argue and convince you all that this decision was not made voluntarily and knowingly on Mr. Hardy's behalf, or it was not a knowing and voluntary waiver on Mr. Hardy's behalf. Primarily because it was based on the unreasonable legal advice of his trial attorney. One of trial counsel's primary deficiencies in this case was never allowing Mr. Hardy to explain his statement to the police. As I'm sure we've all experienced, two people can have a conversation and walk away with completely different understandings than the other person involved in the conversation. That's just the nature of the human mind. And on top of that, when two people have a conversation where they fundamentally misunderstand the other person, and you put that conversation in front of a third party, that third party then comes up with another explanation for what is being said. And this is exactly what happened with Mr. Hardy's statement to the police. Mr. Hardy was trying to convince the police that if he wanted to if he wanted to kill Mr. Dickinson, he could have stabbed him. He carried a knife on his pocket. He was well known for his knife skills. He was somewhat of a cowboy, and ultimately, if he wanted him dead, he would have killed him with that knife. He would have stabbed him. That did not happen. The knife that Mr. Hardy carried on his person was excluded as the murder weapon. But unfortunately for Mr. Hardy, he thought he was telling the police, yes, I beat this man for the inappropriate act that he committed towards my girlfriend. He was sexually, I won't go as far as to say abusing her, but put her in a very, very uncomfortable situation, would not stop. Mr. Hardy was defending his girlfriend. He was convinced, or he thought he was telling the police that, yes, I beat him for these actions, but I did not kill him. If I wanted to kill him, I would have stabbed him. What he didn't understand or didn't know was that the police were understanding him to say, I have these extraordinary knife skills. And ultimately, when the autopsy returned and it showed that Mr. Dickinson died from a fatal stab wound to the back, the police were convinced that Mr. Hardy had confessed, and the prosecutors were convinced that Mr. Hardy had confessed. But Mr. Hardy was convinced that he had not confessed, that he had confessed to the beating, but definitely not the stabbing. He had repeatedly told them, or not repeatedly told them I didn't stab him because he didn't know that he needed to, but he thought that it was understood that he did not stab him. And this misunderstanding is something that trial counsel had the opportunity, responsibility, and duty to clarify at trial. Trial counsel's failure to meet this burden is trial counsel's most serious deficiency. And the resulting prejudice is that the jury never got to hear Mr. Hardy's explanation of his statement to the police. They were left with the prosecutor's interpretation, the police's interpretation, and their own interpretation. Had trial counsel listened to his client's desire to testify, prepared his client to testify, and presented his client's testimony, then Mr. Hardy would have had the opportunity to tell his story with the assistance of a lawyer, of counsel, the assistance of trial counsel's guidance to make sure that what Mr. Hardy was saying was clear and that Mr. Hardy was saying what he meant to say in a way that was understandable to the 12 strangers in the jury box.
So if he had testified at trial, he would have testified truthfully as opposed to his Moman hearing where he testified under oath that he was freely and voluntarily and knowingly choosing not to testify. Is that what you're saying?
Yes, Your Honor.
And the trial court specifically numerous times found the trial counsel credible and found Mr. Hardy not credible. Is that correct, too?
Yes, Your Honor.
How do we overcome that?
Well, I would urge you all to read the testimony. I don't think that trial counsel's post-conviction hearing testimony differs significantly from Mr. Hardy's testimony, especially in regards to Mr. Hardy's desire to testify. Both trial counsel and Mr. Hardy testified that during trial, Mr. Hardy repeatedly asked to testify, and that they then had a meeting. And it was at this meeting that trial counsel gave the erroneous advice that if Mr. Hardy were to testify, he would get punished more harshly. And we all know that in state court, if you're convicted of first-degree murder and don't have an enhancement notice, you're getting a life sentence. There is no harsher.
Didn't trial counsel testify at the post-conviction hearing that he did discuss this issue with his client, and that his concern was the statement that the client gave to police? And I think he testified at the post-conviction hearing that he expressed that concern to your client and said, if you testify, you've got this statement here that's going to be a problem. And after discussing that, the defendant, petitioner decided to, as all set out in the Moman hearing, that he did not want to testify. I mean, I'm with Judge Holloway. I don't know how we overcome it, because then the post-conviction court found trial counsel to be credible, found petitioner to be not credible, and we're left with that.
Well, ultimately, trial counsel testified that part of his decision or his advice was based on the differences in Mr. Hardy's proposed testimony and the police interview. But the police interview came in. So any damage that the police interview, Mr. Hardy's statement to the police, could have potentially done was done, because the interview was in the record as part of the evidence. So similarly, the cooperating co-defendant's statement was introduced, and her testimony at trial differed from her initial statement to the police. So both parties had a credibility issue, and but the co-defendant was allowed to was presented. Her testimony was presented. She was allowed to explain why there were discrepancies. Mr. Hardy, on the other hand, was not able to explain. And to say that the differences were his primary motivator is just unreasonable, based on the fact that the statement of Mr. Hardy confessing to beating this man and the other egregious acts that occurred after. But the big difference was that at the time of his interview, Mr. Hardy was unaware of the stab wound to the back. And he could have explained to the jury, I wasn't bragging about stabbing this man in the back, I was bragging about my knife skills because I didn't stab this man in the back. And while trial counsel came up with a strategy pre-trial that was reasonable, trial counsel failed to adapt to the change in circumstances that occurred during trial, where his defense of third party kind of fell apart when the third party testified, oh, he must have died while I was out.
So when the petitioner testified at the post-conviction hearing, because he testified as to what he said he would have testified to at trial, how did he explain that the victim ended up with like 50 sharp force injuries and blunt injuries? Did the petitioner address that at all in his statement?
He admitted that he was overcome by the heat of passion and didn't recall every blow to Mr. Dickinson, but conceded that he used multiple items because,
Including perhaps a knife, right? Not necessarily his knife, but a knife.
he never, he
Or
did
just said,
not.
or did he just said he was vague as to what he used?
He was pretty specific about what he used. A ceiling fan blade later on, a lamp, a crutch. Mr. Hardy was a very small in stature man, especially compared to Mr. Dickinson, so he did not feel
But the
fists were sufficient.
medical examiner, if my note is correct, like 50 different times?
Yes.
Okay.
And I personally have never hit someone over the head with a lamp, so I don't know what kinds of wounds are.
But at some point in
Left,
time,
but
but at
with
some
a
point in time,
multi-surface
there was
object.
at some point in time, there was a wound that caused the lung to collapse and he bled basically from that,
Correct.
right?
But the medical examiner testified that that was a stab wound that occurred later, likely occurred later, that was longer than a pocket knife. So it presumably, based on the state's theory, this was a second-in-time attack that was not part of the heat of the moment where Mr. Hardy inflicted numerous wounds to Mr. Dickinson.
So there was a pause, so to speak, in the action, and allegedly then later your client, at least the state's theory is, went back and stabbed him and killed him.
Correct. That was the state's theory that was presented at trial, that trial counsel failed to adapt to. Because at that point, it was no longer just one attack in the heat of the moment that went far beyond what anyone wanted. It was a second attack that was fatal and unprovoked. And Mr. Hardy's testimony, proposed testimony that he did not stab Mr. Dickinson, therefore it must have been his co-defendant, was not inconsistent with trial counsel's theory because Mr. Hardy's initial attack was in defense of his girlfriend.
I guess, though, complicating it was moving the body and not reporting.
Correct. And both the girlfriend and Mr. Hardy did that, so they're, equally guilty of
Well,
that.
they brought in a third person to help move it, right? Am I remembering that right?
Mr. Hardy asked a friend, after Mr. Dickinson was deceased, he
Yes.
asked a friend for help,
Yeah,
yes.
But still, move the body.
Yes.
Not to let the police know, but just move the body.
I cannot defend that as the correct course of
No,
action.
I'm not asking you to do that. I mean, I'm just thinking out loud as to what may be premeditation or how that may impact your client if he had elected to testify at trial.
Well, and ultimately, as Mr. Hardy testified at the post-conviction hearing, emergency vehicles did arrive in the apartment complex after Mr. Hardy beat up Mr. Dickinson. Mr. Hardy insisted on retrieving those, and his girlfriend said, "No, don't. I don't want you to go to jail." So he attempted to seek medical care at a time when it would have mattered, at a time that Mr. Dickinson could have been helped, and it was Mr. Hardy's girlfriend that insisted on not doing so. Again, I can't say that that was the right course of action, but it was, once again, Mr. Hardy defending his loved one and protecting her. That was his primary motivation. So I'd ask that you all review the materials, review the trial court's order with an eye for the consistencies where the trial counsel and Mr. Hardy do agree on things like Mr. Hardy wanted to testify. And then look at the things that trial counsel aired in regarding his advice to Mr. Hardy. that is where the unreasonableness comes in, because Mr. Hardy relied on inaccurate, incorrect information in making his decision. So while it may have been voluntary at the time, it ultimately was not because of the erroneous advice. Thank you.
Thank you, counsel. General?
Your Honors, and may it please the Court, Johnny Saraceno on behalf of the state. If the Court will indulge me, I just want to walk through some of the underlying facts, some of the trial evidence, the post-conviction hearing a little bit. I think that'll really help contextualize things here and help our discussion of the individual claims or claim. In 2018, Kendra Ryan and petitioner lived in a small apartment in Knoxville. One day while they were drinking near a gas station, they met the victim, who appeared intoxicated. Ms. Ryan invited the victim back to the apartment to provide the victim an opportunity to sober up and to shower. When they were in the apartment, petitioner went to the bathroom. Ms. Ryan and the victim were seated together, at which point the victim partially disrobed and began behaving inappropriately. I'll put it like that. When petitioner returned from the bathroom, he saw the victim and the behavior he was engaging in front of his girlfriend. He began beating the victim with his fists. Petitioner also hit the victim in the head with a lamp, and the victim suffered dozens of knife-inflicted wounds. At some point while in the apartment, the victim died. The victim was in the apartment from the sort of wee hours of Monday morning when the initial beating occurred until police arrived in the apartment on Wednesday afternoon towards the evening, as I recall. At trial, Ms. Ryan served as the state's primary witness. During her testimony, she said that petitioner beat the victim with his fists, that she tried to stop him, but he continued the attack, and that he began cutting the victim with a knife during the initial attack, and that the petitioner struck the victim with multiple objects, including a crutch. A police investigator was also testified at the trial and said that when he walked into the crime scene that the floor was completely soaked, the carpet was completely soaked with what appeared to be blood, and that the body was soaked in blood. And he testified that during a police interview, and I want to be clear here, it's not that just that the petitioner told police that he was good with a knife. I cited to the direct appeal opinion for this point. This court said that the petitioner admitted to stabbing the victim with a knife. That's in the record. And so at the post-conviction hearing, what we have is testimony from two different individuals, trial counsel, petitioner's trial counsel, and petitioner himself. Trial counsel was credited generally from the post-conviction court's perspective as being a credible witness. He said he met with petitioner numerous times, addressed discovery together, obtained a private investigator, and talked strategy with the petitioner. Because of his investigation, he developed this trial theory that the petitioner acted either in defense of a third party, self-defense, or acted based on sort of adequate provocation, sort of a voluntary manslaughter theory. And this theory made sense specifically because the petitioner explicitly admitted to law enforcement that he stabbed the victim and that he was good with a knife or good with a blade. Petitioner's trial counsel advised him not to testify, and the reason for this is pretty clear from the record. Petitioner wanted to blame his girlfriend, Ms. Ryan, for the incident, which contradicted the trial strategy that had been reasonably developed based on trial counsel's review of the facts, as well as the very clear admission to law enforcement that petitioner stabbed the victim. And his testimony was extraordinary because not only did he claim to have not stabbed the victim, but he claimed that he was unaware of the stabbings. As you mentioned, Your Honor, I believe around 50 stab wounds. He denied this fact despite the fact that the carpet was completely soaked in blood, as the police investigator testified to. And regarding this notion that he wanted to report the account to police, quite the contrary seems to be the case in the record, because the petitioner, I believe, admitted to this. Someone testified. I was a tobacco shop owner that testified that petitioner had asked him to help hide the body. Again, in the post-conviction court's written order, it credited trial counsel as credible generally regarding petitioner's specific contention that they only met 2.5 times. The post-conviction court said this was not a credible statement. Regarding, just turning here now to the specific claims raised by the petitioner, there's this claim that trial counsel was deficient because his counsel discouraged him from testifying. I want to make a point at the outset here that for none of these claims has the petitioner alleged that prejudice occurred or cited to any evidence or raised any evidence that there is prejudice in this case. For none of the individual claims under ineffective assistance of counsel has prejudice been alleged or discussed in the briefing or so far at oral argument. And so I think that's a problem from the start. But turning back to deficiency here, there's no deficiency because the testimony was contradicted the trial strategy, which was reasonable. It contradicted petitioner's prior admissions to law enforcement regarding the stabbings, and it was just generally incredible and remarkable. For the reasons that I think I've discussed already. In response to the above, my friend on the other side here has mentioned that trial counsel should have adjusted his trial strategy when Ms. Ryan testified and the state's expert sort of alluded to the idea that there was a second attack on the victim. The point I'd like to make here is that this testimony, particularly from, well, I'd say both from Ms. Ryan and the state's expert, was oblique. What she said is, I went out to run an errand, and when I came back, there was more blood on the floor. That could have been a result, the jury could have inferred that this was a result of decomposition, an attempt to move the body, which there was testimony about, or some other relatively innocuous reason, not necessarily because the petitioner attacked the victim a second time. I would likewise state that the state's expert was sort of oblique on this as well. He has effectively testified to that the final stab, the stab in the back, that stab that likely killed the victim, there was less blood around that area, suggesting that it might have occurred later temporally. But ultimately, trial counsel recognized the nature of these statements and did his very best, and I think was effective. He said that he cross-examined Ms. Ryan thoroughly and did so based on her inconsistent statements, reflecting an understanding of the record and a recognition of the fact that Ms. Ryan's testimony was both self-serving and at times inconsistent. In other words, trial counsel put the pressure on the state to prove its case and not give fodder through petitioner's erroneous account. So again, there's no deficiency here. There's been no argument or discussion of prejudice, and there can't be prejudice because, quite frankly, the testimony provided by petitioner at the post-conviction hearing was remarkable. Regarding the claim that defendant's decision not to testify was not knowing and voluntary, his trial counsel repeatedly discussed his right to testify with petitioner's right to testify, and again, as this court recognized earlier, or at least asked a question that reflected this understanding, petitioner participated in a MOMON hearing where he acknowledged to the court that he had personally decided not to testify. So again, no deficiency or prejudice here. In the briefing process, there was a discussion about deficiency regarding pretrial efforts and an expert, not hiring an expert. Again, I think I've discussed that trial counsel was remarkably thorough in his preparations, even going so far as to hire a private investigator to further the fact-finding process on his own. And the court expressly stated and credited trial counsel with being very concerned with forming an effective trial strategy. And the record bears that out, again, given his extensive preparations regarding the choice not to, yes, pardon, Your Honor? Regarding the choice not to hire an expert, trial counsel stated that he didn't hire an expert because he was concerned it would backfire, that the expert would find evidence of a second attack on the victim and that he would have to disclose these findings, or that they would come out during cross-examination. He indicated that this was a strategic decision, and it was well-founded given his preparations, given the admission by his client to law enforcement that he had stabbed the victim. And he didn't have an expert testify at the post-conviction hearing, so we just can't establish prejudice on this point. There was also a claim, and this I think is the final issue here, that counsel was deficient for not discussing trial strategy during trial. That's just simply not true. That's certainly denied by the record. For one, Mr. Wallace, trial counsel, spent 2 hours with the petitioner after the state's proof to discuss whether or not he should testify. So they discussed this for 2 hours following the state's proof, and they had prior discussions about the right to testify. Likewise, during trial, at one point, petitioner wanted his trial counsel, or asked his trial counsel to consider cross-examining the victim's family, I believe, or someone related to the victim regarding the victim's character, regarding his personal conduct and his family life. And trial counsel said, I think we should refrain from doing that because that's far too personal. We don't want to just besmirch the victim's character. That will not serve your case. So this notion that trial counsel didn't discuss trial strategy during the trial is just not borne out by the record. And again, petitioner acknowledged and told the court that he personally decided not to testify during his Momon hearing. So this notion that trial counsel sort of overrode petitioner's desire to testify, I haven't seen anything in the record that would suggest that that's true. And I've seen lots of evidence in the record that suggests the contrary, that they did discuss his testimony, potential testimony at length. Unless there are any other questions, we ask that you affirm the judgment of the post-conviction court and deny relief.
Thank you, counsel.
Thank you.
All right, Ms. Moore, rebuttal.
He's a tall man. I would start by pointing out what I think is an example of exactly what I explained in my initial argument. I think that the Attorney General and I are viewing the autopsy report in different ways, because the way I read it, it's 50 superficial sharp force injuries rather than stabbings. I could be reading that incorrectly, he could be reading that incorrectly. But ultimately, it wasn't that there were 50 puncture wounds that throughout his body that could have been the cause of death. It was one fatal stab wound to the back that the state argued was a second-in-time event, far removed from the provocation of Mr. Dickinson's acts. The prejudice, as I noted in my brief and during my initial argument, is that Mr. Hardy was convicted as charged because his story, his version of events was not heard or considered by the jury, and that but for trial counsel's deficient advice, erroneous advice, he would have presented Mr. Hardy's testimony, jury would have heard that, and jury would have had the opportunity to hear all of the facts and make their determination based on an individualized consideration of co-defendant's testimony and Mr. Hardy's testimony. I also wish to address that the AG has argued that trial counsel was more than thorough because they retained an expert. I would like to note that obtaining an investigator on a first-degree murder case is not going above and beyond. It should be a standard. I know that it's not required, but first-degree murder cases are serious and require additional work. And had trial counsel retained an independent medical expert to evaluate the autopsy report and explain it to trial counsel, explain the potential for this second attack that the state so heavily relied upon, if that's what the expert told trial counsel, then trial counsel was under no obligation to turn anything over to the state if the trial counsel did not intend to introduce that expert's testimony. Further, it would have illuminated what the state ultimately did at trial and would have prepared trial counsel for that testimony. And unfortunately, because Rule 13 does not provide funding for indigent defendants on post-conviction, we were hamstrung in presenting prejudice as to that argument. That is a personal pet peeve of mine, and you'll likely hear that argument in the future from me. But I would just reiterate that this court can review the post-conviction matters, find the congruences, and find that while Mr. Hardy's testimony was not credited by the trial court, the main similarities are what brings us here today, in that there was no dispute that Mr. Hardy wanted to tell his story, and he was convinced by someone, as Mr. Hardy said, with a degree, someone he thought was supposed to be looking out for him, not to testify. And learning that his moment colloquy was based on erroneous advice does not require hindsight review. It's Mr. Hardy going to prison and researching and learning more about the legal system and understanding what that advice truly meant, which is, I would argue, the purpose of post-conviction, fixing the errors at the trial court. So that is what I will ask you all to do today, and reverse Mr. Hardy's conviction. Thank you.
Thank you, Counsel.
Okay, unless you want to take a break and then do two. Either way.
Either way, go. We will. All right. Next case, please. Yes. Strong people up there.
Constance